On this morning's Ag Issues program, as always, a pleasure to bring on to the program Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us on the program this morning. Roger, good morning. How are you?
Just fine, Greg. Good to be with you this morning.
As always as well, and let's get to it. A lot to discuss. The first thing we're going to discuss, and I don't know if we've ever talked about this specific situation, that is concerning meal portion of a per diem allowance is eligible to be treated as attributed to a restaurant. What's going on with this case here?
Yeah, this is actually really important to us in ag and in rural areas, particularly as you get further west in the Midwest and the Plain States and out west. A little bit of background on this one. With the Tax Cuts and Jobs Act that took effect starting for tax years after 2017, the business meal deduction was cut basically from 100% to 50%. Now, it's more technical than that, but we lost the ability to deduct about half of our meals that are for business purposes. And this is a big deal for farms that have hired help employees, and they provide meals to them, maybe take them out to the field and put them on the tailgate of a pickup truck, those types of things. You could get 100% deduction for those because those were incurred in the scope of your business. Those are trade or business meals. Well, TCJA cut that to 50%. And then the Consolidated Appropriations Act, which was signed into law in late 2020 as a result of this is virus-related legislation, said that, well, we're going to push that back up to 100% if it's provided by a restaurant. But then they said that meals obtained from a grocery or convenience store, and I want to emphasize that, don't qualify as coming from a restaurant. So you could drive to town, buy the meal, take it back to the farm, provide it to your employees, 100% deductible. Now, that raises a question, and the question is, what if there's no restaurant nearby or within 15, 20 miles, for example, that's reasonable to get to, but there's a convenience store that's got a few tables and chairs in it, and that's basically your restaurant in a rural area. I can't tell you how many times so far this tax season already I've had emails come in from practitioners in North Dakota, South Dakota, Western Kansas, further points west saying, look, we don't have any restaurants within reasonable distance and range of this farm or ranch. Can we take the meals that they go to town, that's the convenience store is within 10 miles, and it's got a few chairs in it. It's got a place for people to sit. You can buy a pizza. You can buy some sandwiches. You can buy some hamburgers. You can sit there and have a meal, or you can buy that food and take it back to the farm. And as of right now, the answer is no. IRS does not view that as a restaurant under their regulations. And that's a really big issue that we're talking to people, the tax writers and IRS personnel, at least I am, saying, look, I understand your position. You're coming from a position in D.C. trying to write this. In the rural areas, we don't necessarily have restaurants that are nearby, but we have convenience stores that can function as a restaurant. Can you modify these regs to give us a break on this and reflect reality? So far, I've gotten nowhere with respect to that. But that's the issue, Greg. That's a big issue in many ag areas.
Yeah, most definitely something to watch as well. Next one that has talked about, has been discussed, and this is California's Proposition 12, which has been very well discussed, but a recent decision on this, Prop 12, was upheld as constitutional.
Yeah, this has been going on for probably about 10 years with California's attempts, I call it California's attempts to regulate agricultural production activities all across the country. And basically, this has happened in different forms, but basically Proposition 12 bans the sale of whole pork meat, and I'm going to focus on pork primarily, but it does affect other ag commodities, but the real focus is on pork. It bans the sale of whole pork meat, no matter where it's been produced. Could be from Kansas, could be from Iowa, could be anywhere. It bans the sale of pork meat from animals confined in a manner inconsistent with California's regulatory standards. And I call it the hokey pokey law. And what I mean by that is they've got rules on cage space and so forth. The animal's got to be able to get up, turn around, not touch any sides. and you say have the same thing for nursing sows, and it's purported to be for health and safety reasons of California citizens. But that, I have a real hard time believing that because we've got all kinds of data that says that even pork that's produced in confined structures that are not as don't comport with California's law doesn't provide or make any type of doesn't cause. Let me phrase it that way. Doesn't cause any health concern. But that's the way they're coming at this, and of course they're trying to regulate the way that pork is produced in other states. And California is a major market. If you've got, I've seen some data that they've got 10% of the national market on these types of sales. Well, there's a dramatic economic impact if you can't sell into that market, as well as if you have to retool your structures on the farm in Kansas, in Iowa, where else, in Nebraska, to be able to sell into the California market. So it's a big deal, and it's been in the courts. The courts most recently last year, a federal court out in California, said that it is constitutional. That what's at issue here is something called the Dormant Commerce Clause, and there's an issue even whether there is such a thing. I know Justice Thomas doesn't believe there is such a thing. Is this a violation of basically a rule that says one state can't cannibalize the economic activities of another state? It's a little bit more complex than that, but that's the essence of it. Can one state dictate the rules of ag production in another state? Well, the U.S. Supreme Court last fall said they were going to hear the case from the Ninth Circuit. So we shall see what happens. We are going to get a Supreme Court opinion on this, and I think it'll be out this term. It'll be out by the end of July.
And this is one, too, that, just a reminder that the rules and regs via the California Department of Food and Ag and State Department of Public Health were supposed to be developed, 2+ years ago, but
right.
They just got released this past December.
Right, in early December. And there's another case besides the one that the Supreme Court has decided to hear. There's another case that was challenging that issue with respect to the regs coming out so late, and the court knocked that down. The case was filed, and there were a lot of problems with the way that case was set up. It was filed more than 3 years after Proposition 12 was approved by voters, and then it got moved. They filed it in state court, which they should not have done. It got moved to federal court. There was a hearing on that back in December, and they had tried the same lawsuit in Iowa that didn't get anywhere, and so the court was really upset in California, saying you filed the same case years ago in Iowa. Why didn't you bring this timely in California, and why didn't you file it in federal court, knowing it's a federal issue that's involved when you get into the Commerce Clause? You filed it in state court, and so they just really hammered the plaintiffs in that case. And although they said that we're going to allow a motion for preliminary injunction to stay pending until a court hearing last week, and I haven't seen anything come out of the results of that court hearing last week in California yet. So it's a big issue. Right. It's going to continue to occupy us in 2022.
Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, is joining us. And Roger, we've got another case, and this has to do with state Medicaid recovery.
Yeah, this is another one that's presently before the U.S. Supreme Court, and this is a really big deal for farms and ranches and families in general. Long-term care planning can be a very important aspect of an estate plan, and even when we talk about transition planning, a farm or ranch, or succession planning, you want to make sure you have a plan in place to deal with the potential of a long-term health care bill, whatever approach that might be, but we have to consider it. The case that is presently before the Supreme Court comes out of Florida in the federal appellate court down there in the 11th Circuit that Florida is a part of. And the question is, we know that a state Medicaid agency can seek reimbursement from a decedent's estate that received Medicaid during life once they die. And they can also recover settlement awards that a Medicaid beneficiary might receive during life. Say the individual was injured in an automobile accident, It has caused such injuries to them that now they have to have long-term health care. Medicaid kicks in. Case settles. There's an award that comes in. How much can the state grab out of that? Is it just for the amount of the award that's designated for past medical expenses? What about future medical expenses? What if there's no designation for future medical expenses? What can the state get, and what belongs to that Medicaid beneficiary to pay for their own care that's not subject to Medicaid reimbursement by the state? What happened in this case was we had an individual down in Florida that was severely injured in 2008, got hit by a pickup truck when she got off of a school bus, is still to this day in a persistent vegetative state. The state of Florida Medicaid program paid a little over $862,000 for her medical care. Her parents then sued the truck driver of the school district, got a settlement of $800,000. Out of that, $35,000 was designated as being for past medical expenses, none of it designated as being for future medical expenses. And the state Medicaid agency came in and said, we've got a lien on the entire $862,000. You're going to have to pay that to us. And the appellate court, in this instance, down in the 11th Circuit, said that we're reversing the lower court, by the way, said federal law does not preempt state law in this case that would permit a state Medicaid agency to seek reimbursement from portions of a settlement an individual gets that represents all future medical care, as well, present as well as past. And so the issue here that's teed up for the Supreme Court is when you look at the federal law, that they said that the Medicaid law merely bars a state from attaching its lien to any part of a settlement that's not designated as payments for medical care. And they also upheld the state's legislative statutory Medicaid reimbursement formula. So the U.S. Supreme Court took the case. They had oral argument last month, early last month, and it's going to be really interesting to see how the court decides this case. But regardless of how they decide it, I think it's going to tee up the issue for state legislatures to address how their respective state Medicaid recovery statutes are worded and what the policy is, what they want the policy to be when you're talking about third-party payments that are made to Medicaid beneficiaries. It's a big issue, and we're certainly going to keep our eyes on this when we, from an estate planning standpoint, for farmers and ranchers too.
Next up, Roger, is a missed tax deadline. This has to do, actually, the plaintiff being a law firm. The IRS notified them about the failure to file employee tax withholding forms.
Yeah, this is a small North Dakota law firm, and they got a notice from the IRS that they failed to file employee tax withholding forms. They didn't respond to that notice, so the IRS hits them with a 10% intentional disregard penalty of about $19,000 on top of the tax that they already owed. And once you get that, that triggers a 30-day filing deadline if you want to fight that in tax court. They filed on the 31st day, and so the tax court said, well, we don't have jurisdiction, and we can't hear the case because you didn't timely file it. Well, they made an argument based on what they think is unclear statutory language concerning that 30-day deadline that the court should have taken their case based on what we call equitable tolling. And it's just unfair that you bounce this out, is what that means. And actually, this case now is before the U.S. Supreme Court. They took the case, and they're going to have to interpret this statute. This is either going to be a 9-0 opinion one way or the other. They're either going to say, well, this isn't important enough, we don't care, so give it to them, or they're going to say, no, you knew you had 30 days, you blew it by one. This is not one where you realize the deadline after the fact. And so it's 9-0 the other way, or we're going to get a split opinion. I can see it probably 6-3. I have no clue how they're going to decide this, but the important aspect of this is we've got to watch tax deadlines, and if they open this thing up to equitable tolling, we're going to have a whole bunch more cases, I fear, dealing with this particular issue in terms of people filing late. It's just going to be a lot messier. Frankly, I hope they just say, no, you're late. You knew you had 30 days. You filed on the 31st day. Look, you're a law firm. You need to know these things. And that would keep it nice and clean for everybody. But Congress, arguably did write an unclear statute, so that's the other lesson in this thing. So we'll see how that happens. There's a lot of stuff, these three cases before the U.S. Supreme Court, and there are other ones out there that are important for Ag 2, particularly a WOTUS one. So there's a lot of stuff to watch coming from the Supreme Court in 2022.
Hey, quick question on that. Say for WOTUS, something should, because I think the session ends this summer, so something should break at least by the summertime. We'll look specifically on the WOTUS decision.
Yeah, we'll get that Idaho WOTUS decision by the end of June this year. That's there. I'm sure of that. We're going to get that this year.
Okay.
Or before this term.
One other thing I want to discuss, of course, you're going to be one of our speakers at our first Farm Profit Seminar coming up Wednesday in Harrington. And you talked about farm succession earlier on a case that you were discussing, and that's going to be the topic of discussion you're going to have there, too.
Yeah, this is really important. There's a lot of, when we look at the age of farmers and ranchers in Kansas as well as elsewhere, there's a lot of land that's going to change hands, a lot of farming operations that are going to change hands. And this has been going on for some time, and it will continue to happen. So what we're going to look at is how do you get started with a succession plan? What do you need to be thinking of? What are the key points on that? How do you identify if you have heirs that are interested in continuing the operation in the family? How do you identify who the managers are? Not everyone that wants to continue to farm is suited to be a manager. They may be suited to be an owner, they may be suited to be the farmer, but not necessarily the manager. So how do you distinguish between those? So a lot of things that I'll try to cover in the brief amount of time that we have. So I'm really looking forward to it and hope people turn out in Harrington on Wednesday evening.
All right, sounds good. Roger, as always, a pleasure. I appreciate it, and we'll see you Wednesday night.
Thank you, Greg. Looking forward to it.
That is Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, who joins us on the Ag Issues program here on 580 WIBW.